Is everyone familiar with the TCPA? Do not call. Okay, yeah. Y'all familiar with that? Who can you call? Anyone? I'm sorry? Yeah. There anyone who's not on the do not call list. Can you contact a for sale by owner if you don't have a client that's interested in that property? Nope. Expireds. If they're on the do not call list, you cannot. We have a resource that they should have given you a copy of when you came on. If not, go to the front desk and Becca can print it out for you with the sign on and password for it. And you want to go in and check all of those. It is between 500 and 1,500 per call or per text if you text or call someone who's on the do not call list. The Woodlands right now is a federal suit was filed against them last month because they contacted somebody 3 times who was on the do not call list. And they filed it in federal court. If you're on the do not call list and someone calls you, basically, there's no defense. This is our policy, and our policy and procedure says here, if you're the one who makes the call, you're the one who's 100% responsible for it. I just want to scare you a little bit before we get started. It's your fault. Yes, if I make a phone call. Yeah, if there's a suit filed that's going to be on the agent, not on Keller Williams. Text is the same thing. Unless you have a business relationship or a personal relationship with them, or they're not on the do not call list. That's fine.
I just want to make sure that you got my message, or they find like subtle ways.
It's probably a spam. I get those also. Yeah. Your number's in my phone, but I don't know who this is.
Yes.
Yeah. Delete, block. They could. Yep. Okay. You're a buyer's agent. Why should I work with you? What's your value? I've got resources. I can go online and look for houses. Honesty. Okay. We do that for clients and customers, though. By our code of ethics, we have to be honest to everybody. You do have a fiduciary duty. And what does the fiduciary duty mean?
The best price that you can afford, the best house for where you are comfortable spending.
Little bit, yes, sir.
Ethical books, it says that the client owes that full obedience and the loyalty and so on and so forth.
Okay, yeah.
Just, professionalism.
Yeah. What's fiduciary mean, though? It would. Basically, it's you put the interest of the client above yours. You know, when fiduciary always has to do with money, we're putting their interest above ours. Now, what else do you do for a buyer that I can't do on my own? Okay, you've got negotiation history. Excellent. Right, but I can call somebody and go into a house, can't I? But go a little further with that.
agent on the other side, that's like,
Your negotiation skills.
Is it in the negotiation thing?
Well, you said that show them houses. Why can't I just call the listing agent and get them to show it?
they have seller's best interest. I have
Good point. Yep. Good. What else? There's 177 things, by the way. Okay. Yep. So you have access to the MLS with and now you understand the difference between HAR.com and the MLS. They're two different things. I'm sorry. Yeah, HAR.com is public. That's what the public sees. MLS is what we're a member of, and that's what we see. So I can have a listing that is on the MLS, but say my client doesn't want it public, so it will never be seen on HAR.com. Yeah, yep. That's where you're going to get your agent remarks. You're going to get measurements. I think the measurements are on HAR.com also.
There will be certain things, MLS, they may be showing MLS and HAR.
Mhm.
both,
Yes,
And certain only on MLS.
certain ones are going to only be on the MLS. We also have access to the coming soon. And y'all understand what that is when we take a listing and, hi. I saw a reflection there. It's like, who is this? Coming soon would be, I take a listing, but it's not quite ready to go public. So I could put it there and it's only seen by members of the MLS, and there's about 40,000 of us. It can stay on the MLS for up to 21 days.
It's only on MLS here. Pretty much on-
Yes, yes, yes. Okay, so we have access to MLS. We can set up showing or set up notifications for a buyer that are going to show them when something comes on the market. If I'm just myself on HAR.com, I have to go in and look for these things. So we're going to see it before someone else. You've got your negotiation skills. You have preferred vendors that have been vetted through other agents, and you have the code of ethics. Now, after you go under contract, we've got access to all the TAR forms. Now, you know the forms that TREC does? We always talk about promulgated TREC forms. Who can use those? I'm sorry? Everyone can use the TREC forms. So the TREC contracts, TREC addendas and everything, those are for the public. And then we have all the addendas and amendments that are done by the Texas Association of Realtors, which you have to be a realtor to use. And those are all designed to protect the public. Yeah. They can only use the ones that are done by TREC. We have a lot that are done by the association. So it adds to it. Yes.
Designed to protect the agent, so everything is.
Texas Association of Realtors protects us. Okay, but everything that the association does is geared to protecting the public. And of course, like in here, when we talk about our fiduciary and what we use here, the first thing I do when I look at a form is how is it going to protect the public? And if I'm protecting my client, then I'm protecting myself, protecting the brokerage. Okay. After you have the forms, everyone's been educated on the forms. Everyone's been educated on the fiduciary, the TREC forms. You got negotiation skills. You have your preferred vendors. You know the timelines. Okay, because what's an option period? You're gonna have that, you're gonna write it down, have it listed. You are gonna interact with the title company. You're gonna interact with the surveyor, the appraiser, the lender, all of those that the general public has probably never, ever dealt with. And then you're gonna get them through closing. So you offer a lot, and you need to be able to articulate that value. No, you want to have that in your mind, because really when I talk about my unique value proposition, I'm going to be more of what do you need as my client. You know, figuring out what your needs are and then what I do to meet those needs. Because nobody wants me to go to a buyer's consultation and tell them that I've been in the business for 14 years, I've sold X number of properties, I've been this, I've been that. I don't care. What can you do for me? How are you going to meet the needs that I have? And either that is, you know, get the best price, get the house closed the quickest, whatever it's, you have to discover that in your buyer's consultation. Now, this is the difference between someone being your customer and someone being your client. Customer would be just somebody from the outside who comes in and says, you know, I need the help, but I don't want to be a client. You owe them honesty, according to our code of ethics. Your loyalty is completely going to be to the seller. Anything they tell you, you have to tell the seller. You can only give them material facts about the property. No advice regarding the property. Get the best price for the seller. You cannot even give an opinion of value. You represent the seller. If you give an opinion of value, it better be the opinion value that matches the list price. No price counseling. No suggestions regarding financing or maybe down payment assistance. You're going to prepare an offer with the seller in mind. You're going to negotiate with the seller in mind. You're going to attempt to strengthen the seller's position. But as soon as they become your client, then everything changes. You've got their interest at the heart. Well, no, you do represent the seller. We all represent the seller until we have a buyer's representation agreement. You would be a sub-agent if it wasn't one of our listings here at KW Memorial. Yeah, everything goes around that buyer's rep, having it documented.
Hey, Mitch, can you hear me?
Mhm.
Hello.
Yep. Yes, ma'am. If so, you're talking about a customer? What would be the best, what would your advice be to making an offer on this house? You look at the MLS, 450,000. Yep. Was that the price I should offer? 450,000. Remember, I represent the seller until I represent you. All right, we're going to talk a little bit about code of ethics. We're going to go over the checklist that we have here at the office, talk about some of the TREC guidelines and broker approvals we need, go over the representation agreement. What do we need to disclose when somebody's buying a stucco home or a house that's flooded or foreclosure? We're going to look at the buyer's disclosure and notices, talk about amendments. Okay. If you must be getting knocked off. Okay. Yeah. Okay. We're going to talk about document. Code of Ethics, Article 9. Everything we do needs to be in writing. We must, according to Article 9, explain the documents. You can't just send a document to someone like the IABS and say, read this. If you have any questions, call me. No, you need to review those. Same thing with the buyer's rep, the contract, go over it. So you need to know it inside out, and mainly so you can also do it upside down. You know, if I took this page and I'm showing you as my customer, it's going to be upside down for me to be able to go through that. And that's what we're going to talk about that today. Compliance. As far as submitting everything for review, as it comes out of option period, send it to us. So then we have the chance to look at the documents and make sure that everything is initialed and signed that needed to be. And if there's any other document that needs to be added to it, you have the chance to make the changes and update things prior to getting down to the day before closing, when basically you can't do anything at that point. We use Command for compliance and for tracking everything and for your DAs. The broker must maintain all substantive communications. Now, this is going to be text messages, emails, anything that's substantial, like let's do a price reduction. You want to make an offer on this property. And it's not, let's meet on Friday to show the home. And the person with the most documentation is usually going to win. If you have a talk with somebody, follow up with an email. You're making sure that first you have agreement, both parties are understanding, and you've got it documented. Like in, let's do a buyer's walkthrough before closing. You've documented that you have given that to them. And if they decide, no, I don't want to, you've educated them. And that has saved. One agent didn't, it cost $5,000. One agent did, and they got taken out of a lawsuit because of having that documentation. Now, where are y'all licensed to do practice real estate? Texas. Yep. But TREC says that the broker needs to establish geographical competency. Now, what we've decided here, our broker, is that you should be geographically competent in Harris County and the counties that touch Harris County. So Fort Bend, Brazoria, Galveston, Chambers, Liberty, Montgomery, and Waller. We also leave it up to the agents to decide, are you competent to work in all of those areas? Anyone familiar with Galveston County? Not much. Okay. You're probably not competent to work there. Can you get competence? Yeah, you can. It's going to take a little bit of training and education, a lot of research on your part. Plus, I live in Fort Bend County. I really don't want to drive to Liberty. Yeah, that's a long drive. I think when I looked these up, the Houston Metropolitan is bigger than 4 states combined. It's huge. And what we also have talked to, and people say it all the time, I'd rather receive a referral than pay a deductible or your E&O or paying a lawyer, a retainer. Yeah. And driving from my house in Richmond, Fort Bend County, to Liberty takes up half the day. If you're going to work outside of one of these counties, you have to get written permission from the brokerage. If you're going to come and talk to myself or Michael, and it'll ask you, what do you know about that county? What do you know about that area? Have you joined the MLS for that area? Because you need to be able to do CMAs. And now, when you get out of school, figured you probably know how to do residential real estate. How many of y'all were trained while you were in school to do leases? Yeah, they didn't even talk about leases. You know, it's 9 pages to buy a house and 17 pages to rent a home. Yeah, big difference. So take classes on those. If you're going to be doing farm and ranch, commercial, you must have written permission from the brokerage first and get trained on those because it's a whole different ballgame. Any questions about competencies and where we can work? Yes.
Said that, access of MLS on these, except these counties. So when we have access on MLS,
Mhm.
so do we have a certain access or?
No, you have all of Houston. With our MLS, we have an agreement between Austin and San Antonio's boards. So what they have listed also shows on har.com.
Texas.
No, not the whole Texas. No, there's certain places they don't have an agreement with our MLS. Okay. As far as listing the home, refer it. Yeah. It's also your fiduciary to the seller because it is about 3.5 hours to drive to Killeen. So if you get a call saying, hey, I'm pre-qualified, I want to see this home, can you show it to me this afternoon? Can you drop everything and drive 3.5 hours? I understand, but your fiduciary to the seller is to show it if it's somebody who's not represented. And how familiar are you with Killeen? So have you ever lived there? I graduated from Killeen High School. Yeah.
So my ex, his family.
Okay. Hmm. Yeah. Mhm. Now, am I competent to sell in Killeen? No. I moved out of Killeen I got out of high school 42 years ago. So probably 41 years ago. I am not competent. I mean, when I was there was 2 high schools and Ellison High School we were the first graduating class. I was the 100th graduating class from Killeen High. And now there's like 7 high schools. So no, I'm not competent. Do I know agents up there? Yeah, so I can refer them. I get a 25% referral fee and they do all the work. And now if your in-laws are moving to Houston, well then great, you're their buyer's agent. All right, so our checklist. No, I've been back a couple of times. I have high school friends that live there and it has changed way too much. Our checklist, they're all online on .loop and DocuSign. They're also on the agents only KW Memorial site. When I set these up, I tried to think about the order that you're going to use the documents. So every single checklist, the very first document is going to be the IABS. Okay. With these also, I put the TREC number in the last edition for them. So the IABS hasn't been updated since November 2nd of 2015. The next form is the KW Memorial Buyer's Disclosure Notice and General Information, which we updated in October of last year. This document took 5 different documents and put it in one. There's a lot of stuff that we need to remember that we need to educate our clients about. This puts it in paragraph form, so you could just go right down and talk about them. Buyer's Representation Agreement, last updated September 8th of 2022. They will be updated this year. They will be updated before July. Yeah, because of the lawsuit, the settlement. Now, that is something that TAR is working on at the moment. The Buyer's Representation Agreement and Listing Agreement are association forms. The state TREC board is looking at possibly doing a buyer tenant agreement. then make it statute. So by law, you would have to do it. But we're still waiting. They're kind of waiting to see what TAR does, and then they may use something similar for them. But that's yet to be seen. Before showing properties. The no, the agreement is the same thing. The buyer's representation agreement. That's the same form. Is that what you were asking? Oh, I'm sorry. Yeah. Buyer's representation agreement first, buyers, either way. I know some people do them all at once. With the KW form, there's a place for your CMA. You could go over this form, and then when you actually get a property that they're interested in, you could fill in that box and there's a place for initials. Either way you want to work it. Buyer's representation agreement, I probably need to move that now because it must be before showing properties, before you enter a house. We're going to talk about the paragraphs. I'm going to skip that red part. A seller's disclosure, unless it is not required by statute. When is a seller's disclosure not required? Okay, new construction, never lived in. Bank owned, When else? New construction, bank owned, estates. So if it's being sold by the estate of somebody, they're not required to do a seller's disclosure. If it is held in a trust, they don't have to do a seller's disclosure. There's a couple of others in there. If you're doing it family member to family member, seller's disclosure is not required. If the property is less than 5% of the total value, the improvements are less than 5% of the total value of the property, seller's disclosure is not required. How do you just figure that out? Got to get an appraiser, probably. I always recommend go ahead and do a seller's disclosure. If I'm buying a property for investment and I just do some improvements on it and I sell it, I have a seller's disclosure, even though I've never lived there. Yes. Yes, you have to do one. If you are representing an investor, make sure you look at the seller's disclosure. I'd never, hardly ever send a seller's disclosure back if it's mostly filled out. They had put unknown on everything. Yeah, so I sent it to the agent, the listing agent, said, hey, can you show them your listing pictures? Because they say they don't know if it has plumbing. And I see pictures of bathrooms and of a kitchen. Now, our fiduciary is to protect that seller. Our fiduciary to our buyers with the seller's disclosure, when they initial that, they're saying they received it. They're not saying it's right. They're saying they received it. Now, as a good buyer's agent, you're going to read it. And if there's any questions on there, you're going to point it out to that buyer. You may want to get them answered before they sign that seller's disclosure. Okay. We want to see a copy of the MLS and pending status. And what we're looking for there is that you're getting credit for the sale of the property. That's going to be the big thing right now because it used to be because commission was on there. That was one of the documents that held our compensation. It's going away come July. And we'll want a copy of the tax record. We want to see that the person who is selling the property is the person who owns the property. And in the last 2 years, it's been a big thing with seller fraud. People are contacting us. A lot of times it's been on properties that, unimproved property that has no lien on it. They're calling us. We've had it on homes though. They're calling saying, hey, I want to sell this property. I'm out of town. Can you just put it on the market? We want to make sure that tax record matches up. Right. After closing, we're going to want a signed closing documentation, and title sends you all of this. And always a buyer's walkthrough and acceptance form. That was updated in 7/8 of 22. If y'all hadn't seen it beforehand, it's a fantastic update. It's a lot more questions on there, and there's a place for them to say that not to do a walkthrough, and they're signing it. So not only does that document that we gave them the opportunity, they chose not to do the walkthrough. And a copy of the title commitment. Right, the buyer tenant representation agreement, the Texas 1501, like I said, be updated this year. It is a requirement of our brokerage that you have one before you go showing properties. And it is also a requirement of the settlement. Most likely within a year, it'll be a requirement by the state. And this defines the obligations. So you're letting the buyer know what your obligations are to them and the obligations they have to us. It tells them what the fees are, how much they're expected to compensate us for, how that compensation will be paid. They agree to go to mediation. And one of the biggest paragraphs, I think, is limitation of liability. So they're saying, and we'll go over that paragraph, if you're out showing properties and I step on a rusty nail, that's not the brokerage's fault. They're gonna hold us, indemnify us from any type of lawsuit with that. The agent and the brokerage. Yeah. Little protection. They can still sue you, but it's nice when you have that and say, well, they already agreed to indemnify us for something that wasn't our fault. Have you ever been to a professional, let's say a doctor or a lawyer, where you didn't have to sign paperwork before you saw them?
I have to say.
Yeah. So come on in and I'll, look at you and do a physical exam and everything, and then we'll decide whether or not to do paperwork. It doesn't happen. So it starts you out on the right foot, defining us as professionals. It's also time for, when you're talking about your obligations and your expectations, of letting them know, what are your working hours? Are y'all 24-hour agents? Almost. You should not be. I usually get up about 3:30 a.m. If you tell me you're a 24-hour agent, I may just call you at that time because I have a question. And if you don't answer, right. And setting that expectation makes it a lot easier for you. When I've showed properties, I've always set the expectation. I work from this hour to this hour, and on Saturdays, and at X time on Sundays. With agents up here, as far as being the compliance broker, my hours are from 7 A to 7 P. I will respond to text messages or telephone calls, usually, unless I've got something else going on. But after that, I'm not going to. Just, you need to have a shut-off time. Not only is it part of our code of ethics to have everything in writing, it's now part of the settlement. Without a buyer's representation agreement, we can't sue for compensation. That must be in writing. Not often. Yeah, really. We must have it in writing before we can go after someone who doesn't pay compensation. Are y'all familiar with the lawsuits? Being new agents. This came out, a group of lawyers said that because of our NAR saying that the selling agent should offer compensation to the buyer's agent, they said that raised prices and it was unfair competition for the buyers and the sellers. The jury found that it was an antitrust violation, and the settlement was $1.1 billion. Yeah. So we did NAR did a settlement for $4.4 million with the agreements that we've been talking about. These are things that have to change. Keller Williams did in the settlement for 11 million. That's our benefit of it. With the settlement, we must have the buyer's representation agreement signed before we show properties. Compensation can no longer be on the MLS or any website that is controlled by the MLS. We can have it on our internal website, like KW Memorial. We could put our listings on there showing what we're, if there's any compensation offered. That's gonna be something we're trying to figure out. Yeah. You could put it on your personal page. You can put it on Facebook. Yeah, anything that's not controlled by the MLS. Yes, you are allowed to ask them. That's gonna be the big thing now is we're gonna have to have documentation and do that negotiations prior to them making an offer. We'll talk about that when we get to compensation on the buyer's representation. Trek is looking at paragraph 8 of the contract when it talks about compensation being held someplace else. Either adding something there or removing that paragraph. On page 10 of the contract is where they have compensation, little line down on the bottom, talking about changing that. Trek is also looking, writing a couple of addenda that we'd be able to use. Of course, it's only been about a month since the settlement. True, still trying to figure out how things are going to work. We have a couple of documents we can use already, like agreement between brokers would be one. Yes, sir.
That did not affect what we were thinking of. That would match the commission to buyer.
No,
No, it's still 6%, it's still.
Nope.
Negotiable. Negotiable.
That's the thing, it's never set.
it's never been set. Yeah, they were saying that it was a certain amount all the time, which wasn't true. And I can tell you it wasn't true because of all the contracts I review. A lot of people don't offer a full 3%. Sometimes it's only 2%. It's always negotiable. What we have to do is let our sellers know that they do not have to pay a buyer's agent. They can choose not to. As far as we're concerned, as listing agents, and this is covered in our listing class, what are the value of having a buyer's agent to the seller? Yeah, they bring a lot to the table. Like if they're not, if they don't have an agent, this buyer is showing up at their house with no background. We don't even know if they're qualified to buy the property. And when you're dealing with someone who's not represented, it's a benefit to that seller to have a buyer's agent. We talk a lot about that in the seller's class. Any questions about the settlement? Okay. Okay. We can ask the listing agent if the seller is offering compensation.
And then when
They can't, they still can. Yeah. Mm-hmm.
Can the seller, speak to us directly? I thought we read somewhere that they can't pay us. I mean, they have an agent that represents them.
Right.
But there would not be.
They would go through their agent, correct. Mhm. Mhm. Yeah,
If the seller doesn't pay it,
we'll talk about that at that paragraph. Okay, you're a little bit ahead. Not real soon. Okay. You look confused. Mm-hmm. Ah, that is one of our biggest arguments. Yeah, or none.
They still have, like, this thing, they still have those percentages to their, to their seller, right? The seller.
Well, the seller, the listing agent and the seller are going to negotiate those at the listing agreement. And then the listing agreement can share that with us as buyer's agents. And you're right, that's one of the issues with the settlement. It's not going to be on the MLS. There's no more transparency because I can get your name and I don't like that name because it's obvious you're not from South Texas. So I'm not going to offer compensation to you. But your name's Jane Smith. Okay, I can offer compensation to you. How do I prove any if there's fair housing discrimination? Very, very difficult. We'll see. And also is going to affect your VA buyers because a veteran cannot pay compensation to their agent. And if I'm a buyer, maybe first time home buyer, I have to try to collect all that money for my down payments. And now I'm going to have to add more to that so I can be represented. Or I have to choose to go into a transaction unrepresented. Yeah, those are the same questions we had and the arguments. All right, so the buyer's representation agreement. Who are the parties to this agreement? The buyer's representation agreement. The buyer and the brokerage, yeah. Okay. When you're doing the buyers in paragraph 1, use their full legal name. So ask them, what is the name on the ID that they'll be bringing to title? We do contracts challenge. One that we did, I was playing the part of the buyer. Oh, Mitch Rainey. You know, most of the agents in the room put Mitch Rainey on the contract. That isn't my legal name. You need to have the full legal name. Give us as much contact information as you can. Address, telephone number, email address. This is if something happens and I need to get a hold of these buyers. If something happens to you, something goes on with the contract, and I need to talk to those buyers, I know how to get a hold of them. Brokers always can be Keller Williams Memorial with our contact information. Who is just a buyer appointing the brokerage to be their sole exclusive agent for the purpose of buying property in the market area. Paragraph 3 is definitions. Acquire means to purchase or lease. Closing is when the title changes hands. So closing and then when the money goes there. And then market area. That means the area in the state of Texas within the perimeters of the following areas. Must be specific. No. Baytown, that would be specific, yeah. Okay, you could put Harrison, Fort Bend County. Yeah, please don't put Houston and surrounding areas. What does that mean? If you look it up, it says things that touch. So Richmond and Rosenberg do not touch Houston. Okay. Now, this is someplace where you can start to negotiate to get this signed. You could put on here 123 Main Street. You could put the properties that you're going to show today. Then you do an amendment to the buyer's representation agreement. Okay. So it can, on C, yeah, that's if they're real leery about signing, which you'll get. You can say, well, let's do this for just these properties that we're showing today. I'll be your agent. And you do want to have my knowledge and insight and everything about properties, correct? Yeah. So it can be as small as a property, it can be a county, it can be a subdivision, it could be a town. Texas, because it's going to be kicked back. So with this, can a buyer be working with two buyer's agents at the same time? Well, that depends. Market area. Yeah, so you're representing them in Harris and Fort Bend County, but they may buy in Liberty County, and I'm going to represent them in Liberty County. So yeah, they can have multiple buyers representation agreements as long as the market area is different. No, no. Yeah, and you may not be geographically competent to go out there. Yeah.
That's a big
Mhm. Property means interest in real estate. And these can be properties that are listed on the MLS or not, for sale by owners. New construction encompasses all of it. Second place that we can do some negotiation to get them to sign a buyer's rep is the term. Unless they're leery, I'm going to put Harris County as market area, and then I'm going to put May 3rd through May 5th this weekend. And if I like working with you and you like working with me, Monday we can extend it if it need be. There's an amendment to the buyer's rep. All you have to do is amend it. Mark, they would have to sign that. Yeah, so you'd extend the termination date, expiration date. I like to have the agreement start when I'm showing properties. Or even if I'm doing a buyer's representation agreement today or consultation today, and we're not going to show properties till this weekend, I still want it to be the day that I'm talking with them. You get them under contract. And with the expiration date, it can be very short, like a 1 day, or it could be long, depending on what type of property you're looking for. You can terminate this in writing. Yes, you can. Either side can. With the term, look at the type of property you're looking for. If you're looking for high-end luxury property, it takes a little bit longer than what it does to find a $200,000 home. With the term, do I want to go steady with you for a full year because I find out after 1 month you're crazy? Or maybe I just want to date you for a couple of months and then we'll decide if we want to go further. No, that's experience. Right. And then 5 and 6 talk about obligations. What are the obligations of the broker? To use your best efforts to assist the client in acquiring property in the market area. Assist the client in negotiating the acquisition of property in the market area and comply with all the other provisions in this agreement. So we're telling them what we're going to do for them. And then what is the client? What are we asking them to do with us? To work exclusively with us in the market area. Inform brokers, salespersons, sellers, landlords with whom they may come in contact with that they're represented by you, by this brokerage, and comply with everything else. When we're talking here, let them know, go to new construction, go to open houses. Just let them know that I represent you. There was an agent at Family Reunion a couple of years ago, and he had a business card. The front was his information, on the back was his client's information. Just actually their names. I don't even think he had a telephone. I know he didn't have a telephone number on there because he told his clients, go to new construction. But when you talk to the salesperson, give them my card. And you're licensing, we are registering them with that new seller. And he'd say, they're like used car salesmen. They're going to start calling you, trying to sell you that property. Let me earn my compensation and take those calls. All right. Okay, representation. Each person signing this agreement has the legal capacity to sign the agreement. They're not now a party to another buyer's representation agreement in a same market area. They represent that any information they give us is going to be true and correct. And if they're working with a relocation company, what's the relocation company they're working with? So you're going to have to deal with that relocation company, and you're going to have to probably give them about 40% of your commission. Hey, 0 or 60%, the best way to not have to pay that 40% compensation is have a really strong pipeline. Yeah, because if you're going from paycheck to paycheck, you kind of take everything and you get burned. New agents have a habit of doing what you need to do up front. So you get busy and you forget to do what you need to do. So you get everything closed and then you're looking and I have nothing to do. You got to keep up that constant lead generation. You understand that we cannot sign for one of our clients. Yeah. Can you have a POA for your client? Power of attorney? No. No, power of attorney would be, I'm your client and I'm going to give you the right to sign in my behalf. Yeah, no, you don't want that. You want to keep it at arm's length. There's no conflict of interest. A client can have a power of attorney though. Maybe I'm going to be traveling when closing comes, so I'm going to give my power of attorney to my brother, and he's going to sign in my behalf. LegalZoom. Or you can go to the title company. They have blank ones that they will use for real estate and other things. All of us should have a power of attorney with somebody and a durable power of attorney. It's life skills. Okay, intermediary. What is intermediary? People online are really quiet. You? The broker represents both parties. Now we talk about intermediary in 4 different forms. Good point. You're going to ask them, do you want to see the 400 properties that are listed by Keller Williams Memorial? Yes, I do. Well, in that case, if you decide to make an offer on one of them, our broker would be an intermediary, which means at that point, he can't give advice to either side. He's not going to tell you that that seller will take 10,000 less, and he's not going to tell that seller that you're qualified for 100,000 more than what you're offering. The answer? Yeah, you're just kind of getting permission now to show those properties. So the first form that talks about intermediary is your ABS. So you're kind of introducing it at that point. When you get to the buyer's representation agreement, you're saying, do you want or will you entertain intermediary if you decide to purchase a property listed by Keller Williams Memorial? It's only Keller Williams Memorial. And then the last step is the intermediary form, the 1409, I think, which says, I understand and I'm willing to move forward with this transaction knowing that the broker will be an intermediary. The brokerage, yeah. Michael would be the broker of record. Mm-hmm. That's okay. Oh, you can do, just because it says intermediary, they're going to see everything. Yeah. If they say no intermediary, then you cannot show just Keller Williams. Can't show those property. No. No intermediary would be not showing any of Keller Williams Memorial. Intermediary is showing everything on the market. Okay. Here at our office, we don't do intermediary without assignments unless you have written permission. As a brand new agent, you're not going to get written permission to do intermediary without assignments. So don't even ask. And that would be, you have a buyer's representation agreement and the listing agreement. And it's real hard to do your fiduciary. Because at that point, you can't give any advice. None. Yeah. And you can refer it out to somebody, get a referral fee. Give them 3 agents to talk to. I've been licensed for 14 years, been a broker for half of that. I wouldn't do intermediary without assignments. It's just not fair. It's not equitable to my clients. So I'm going to refer out the buyer in most cases. Mhm. Right. Yeah, Cliff, I am not hearing anything that you're saying. Maybe saying.
Hear me?
Yeah. Well, it's showing that it's unmuted.
Can you hear me?
He can hear me. Just his mic must be not working on his computer. Let's see if I have. Yeah. I'll just try to keep a better eye on the chat. All right. When you're going into a possible intermediary, before you show the property, you're going to talk about it and go ahead and get that intermediary form signed by your buyers. Before you do any negotiation, you need to contact that listing agent and talk to them about intermediary, and they need to have their seller go ahead and sign the intermediary form. And then you start your negotiations. After both parties understand the broker is an intermediary. Yes.
If they don't want to sign it,
Then you have to move on to the next property. I've never had an incident where the seller has not wanted to do intermediary. Take that back. We've had one. And it was an estate sale. It was more family dynamics than anything. One sister did not want to sell mom's house and the other siblings wanted to. So she wouldn't allow intermediary. Yep, 1409.
legally, what the- Majority wanted to sell.
That is something they have to figure out on their own. You can give them advice. Yeah. I would go back to why are they selling the house? And what was their motivation to sell this property? They can't decide if anyone's going to live in it. Nobody wants to live in it. They're trying to get the funds out of it. Maybe they have to sell it. So you go back to their motivation. When you're dealing with an estate and there's multiple people, sometimes it's easier to get for them to get a lawyer and they decide the one person that's going to be responsible. Gary Stern out in Sugar Land, he was dealing where there was 9 heirs. Yeah, so they got a lawyer, a family lawyer, and decided who was going to be the responsible person, who had the right to sign for everything. Otherwise, you're trying to get all those people. It could be a probate lawyer or just a family lawyer to write it up. Mhm. Yeah, practice family law. Paragraph 9 talks repeating clients. And you're going to let your clients know that you're a buyer's agent. I'm working with multiple buyers. They may be interested in the same property you are. I am not going to tell them anything that you've told me. And I'm also not going to tell you anything that they've talked about. It is tough. It doesn't happen very often. It's kind of rare that you actually get 2 clients who are, yeah, there's so many different properties. Paragraph 10 talks about confidential information. Anything they tell us is confidential forever, unless it's something that has to be disclosed by law. We do not have a doctor or lawyer agreement with people. So we can't withhold information.
Something that can be considered confidential that you might in your head be like. Comment. Whatever you understand.
I think I understand. I can't think of anything that would be common that I would have to just, more so on the seller side. Sometimes they can tell you, well, hey, we had termites a year ago, but I really don't want to tell anybody about that. That is not legal. It's a material fact. And even if they don't tell, we have to. Yeah. On the buyer's side, not as common. Actually, I can't think of anything a buyer may tell you that would have to be disclosed.
Situation like that. I mean, that relationship is gonna be rocky.
Well, yeah, and maybe you don't even want to enter into that relationship. 'Cause if they're already asking you to withhold material facts, it's probably someone you don't want to be in business with. Yeah.
Yeah.
Confidential information with the buyer may be that they work with you, they don't buy a property, but a year from now they decide to work with her. You can't tell her that when you worked with them, they were qualified for $200,000. Yeah, that would be confidential information. Yeah, basically. And you've got to be careful even when you're here in the office talking about, I've got buyers are qualified up to 300,000, because you may enter into an intermediary and her responsibility is to tell her seller, I know these people can pay more for that house. I know they're qualified for 300,000 and they're only offering 200. Be careful the information that you talk about, even within the office. Now you could say, I've got buyers who are looking for a 3-bedroom in XYZ. That information you could give. Yeah, stay away from what they're qualified for.
What they listed later higher.
And you'll see that. My question when I see that is, it didn't sell at 250,000 and now you're gonna list it for 300,000 and think it's gonna sell? Unless they've gone in and done a lot of repairs. Maybe they went in, they totally gutted the kitchen and rebuilt it. Then that would justify that price increase. But a lot of times you'll see it, and I've called, I saw you did a price increase. What's going on? Well, they decided more for the property. Okay, the market's already told you it wouldn't sell at 250, so you're going to make it 300,000 now? It happens not very often. And most time, if it's a good agent, it's going to be because they've done improvements to the property. Broker's fees are negotiable. If you've gone, when you're doing your buyer's consultation and shown your value, it makes it easier to talk here. So how much do you charge? What type of compensation do you ask for as a buyer's agent? Nothing's typical. Lose that word. Go ahead.
Said it. But if the seller go higher and
Yes, on the, come to the listing class, because in the listing agreement, paragraph 5 is total commission. Paragraph 8 is how that's going to be split. Here, it's going to be total compensation. How much do you charge a buyer to work with them? And it's totally up to you. Now, how much does it cost you to represent a buyer? If you haven't represented buyers, you probably don't have that number right now, but you need to figure out what it is. And with that, you're going to take into consideration your HAR dues. They're only once a year, and they give you a lot of value. Actually, our MLS is the #1 in the country. Bob Hill, who's the president, has been for 20-some years. He is guest speaker all over the country because of what we've done here in Houston. Ah, so your HAR dues, your Keller Williams dues, your Keller Williams monthly. How much does it cost for your car? How much does it cost for your insurance? How much is gas? Okay, figuring out, what it costs me to work with a buyer. So then I have my baseline. Everybody is in the business to make money, so I know I can go no lower than this. Anything above that, then I'm making a profit. Figuring that out. There's all different ways to talk about your compensation.
Buyers agreement.
The buyer's agreement, right? This is all about the buyer. There are agents who do, they do a percentage. Let's say we have 3, 4, 5. Studies show that people like to go for the middle. Okay. You've got someone that says, well, I was really thinking more about this price. Okay. This is what I offer at this compensation. This is what I offer at this rate. At this rate, I will show you 10 homes. You decide which homes. Yeah. Yeah. It's kind of an a la carte. Nothing says that you can't charge per hour like a lawyer does. Take a retainer. You can also charge a flat fee. You just have to figure out the model for your home, your business. Yeah,
That's that they're encouraging the staff.
it's just options. It's just options. You may have to put it in special provisions. Okay, this talks about a percent of the sales price.
So what would you put in this?
And you would have to put in special provisions on this form. I haven't seen what they're proposing for the new form. They're just starting to work on that. So the first line is going to be of the gross sales price. Now, number two is if they're renting, they're going to lease a property. You've got a percent of 1 month's rent, or a percent of all rents to be paid over the term of the lease. The second one, I like that because if I'm representing a tenant and they decide to do a 2-year lease, then I'm going to be compensated for the full 2 years. On the reverse of that, let's say they sign a lease for only 6 months. Is it equitable for me to take 75% of 1 month's rent or take a percentage of each month's rent? So it'd be, say, 0.25% of a month.
It is.
Yeah, for 2 years,
6 months, you say?
then it would be less. Well, it would be for that tenant. Yeah. And then if you're a good agent, you're going to be working with them, and in 6 months from now, you're selling them a house. Yep. Right. Source of payment. The first thing we do as agents is ask the seller if they're going to be paying compensation, or the other broker. If they don't or refuse to pay, then we're going to turn to the buyer. And with the changes, they may not be paying. So it's going to be the buyer's responsibility, as it always has been. And they need to understand that.
Right.
They may not. And that's a question you're going to be talking to them about.
Could say X% or.
No. Oh, no. It has to be the exact. That's part of the settlement also. And you also cannot collect any more than what you have on the buyer's representation agreement.
But I mean, where is the-
Mhm. You can have different options for them. No, and you can decide what your normal compensation is.
Just, the thing is that
Yeah. Cliff, for number 2, so you're talking here. If the listing agent is offering, the seller's offering 50%, but on your buyer's agreement, you have 75%, then it's going to be the buyer or the tenant's obligation to bring that, pay us the extra 25%. Yeah, we always go to the listing agent, the seller, the landlord first. Whatever they don't pay is the responsibility of the buyer or tenant. Does that answer your question?
That's with the same way too.
Oh, you're going to inform them before you show the property. Yep.
so you can ask.
You're going to have to. Are you offering compensation? Yep. After they take it off of the MLS, that is going to be something we have to do.
I've heard some of the listing agents say this is non-negotiable contract. I get that.
W- Right now, the compensation, the unilateral agreement between brokers, we cannot, if they have 3% on the MLS, we can't go to that broker and say, hey, I really want 4% on this. You would turn around to your buyer and say, hey, remember, we agreed to X% and they're only offering this percent. Then it's the buyer's responsibility to pay the difference.
Just be proper, and if the contract said the listing agent, this is not negotiable, this is our fee. And you say, I don't agree to that. However, I'm willing to negotiate.
You-
You leave a note, would they have to show that to their client and say why you got rejected?
Yeah, they would have to. You have to tell your clients everything. And that's what we're really kind of in a gray area right now, because we're not in that market yet.
Basically not allowed to negotiate a shit fee, but this thing-
With a listing agent at the moment. When we go forward, yeah, we're probably gonna be doing a lot of negotiation with that listing agent. But at this point, we're negotiating our compensation with our buyer.
You said that was. So Cliff has time.
Well, it's gonna be right here on your buyer's representation agreement. And they're gonna have to write a check, certified funds, when they're doing the lease.
Is there like anything that you can add to this? Like agreement? So where it states. that the client has agreed to pay.
That is the party.
Yeah, this is the agreement with the broker.
That's what I was saying, that you're gonna take 50% now, if the seller is offering it, then it'll cover. Seller.
Isn't.
I.
You got it.
If you settle for like less, like say,
They're asking, they can't hear y'all, so.
so per se, if you put 3%, you're charging 3%.
Mhm.
And there's a home for 2.5,
Mhm.
like, and then you just decide, and you're like, you know what? Don't worry, buyer, you don't have to pay me the 0.5% or the 1%. Does that have to be updated on here?
I would do an update for it, an amendment. But with that amendment, I would put for the property address,
Just for that?
just for that one.
Okay.
And probably before I negotiated that, I would negotiate, hey, they're only offering, let's say 2.5%. I will waive that 0.5, but you have to promise me in the next year, you will send me 2 referrals of people who are looking to buy, sell, or invest in real estate. Mm-hmm. Yeah. Talks about when it's earned. It's when the client enters into a contract to buy or lease a property in the market area. Either client breaches this agreement, broker's compensation is payable at closing and funding. When the client breaches a contract to buy or lease a property in the market area, or client breaches this agreement. Closing and funding, we're going to be paid. Let's say you're in a contract, you go through all the contingencies, and there's like 21 different ways for a buyer to get out of a property. Let's say they don't have any of those, and at the last minute, they say, I've changed my mind. I don't want to buy a property anymore. Well, we've already earned our commission. At this point, you owe Keller Williams Memorial this much money.
If they back out last.
If they back out without contingency, a contract reason to be able to back up. Just because they feel like it. Had that happen this week for a seller. Got down where they were closing this week. The seller decided they changed their mind. They didn't want to sell the property. They were not represented. They're paying that buyer $60,000 to get out of the contract. It was a high-end property. So they're refunding the earnest money, they're refunding the option money, and they're writing a check to that buyer for $60,000 so they can get out of selling their house. It was $1 million something. Well, they can either pay that, or the buyers who we know have the money can sue them for specific performance. Mm-hmm.
So they only could do one or the other, sue for specific or go ahead and take this.
Take the earnest money. Yeah, with the release of earnest money on that form, it says that all parties release all from liability. Okay. No, that was on top of the earnest money. Hmm? I doubt it. I wouldn't. No, they said they just did not want to sell their house. They changed their mind. They were going to stay there. Mm-hmm. Yes, ma'am. Use the mic, please.
So is there a contract perhaps protecting, I guess, the listing agent or the buyer? Say they do decide in another month or so, what kind of contract would that be and how long would?
Listing
it kick
agreement,
in?
the listing agreement, and the buyer's representation agreement.
Okay.
That's the contract that covers all of that.
Do you know like a number of days that it would like cover?
Whatever's in the
It
term.
varies?
Yeah, it's going to
Oh.
vary. It's going to be in paragraph 4 on this one. We talked about the term, and same thing with the listing agreement.
Okay.
Yeah, because that seller would present it. If he had been, he would be paying $60,000 to the buyer to get out of it, and paying the listing broker the amount that they had agreed to.
So he was like what was
Blake, I'm sorry. He didn't. He was representing himself. Another reason why you need to have an agent. You need to have a realtor. I guess so. Yep.
You had a whole college degree.
Yeah. And more money than sense. Okay. Any other questions about your compensation, when it's earned, when it's payable? All right. So you have X% in the first line there. You talk about all of this, and that buyer says, well, I cannot afford to pay you anything. So I really don't want to see any homes that don't offer compensation. You can do that. You put it in writing in special provisions. Buyer does not want to see any home not offering X% compensation to the buyer's agent. Yeah. Yes, sir.
this, buyer, rep we are seeing right now, that
Mhm.
is the track buyer's rep.
No, Trek doesn't have a buyer's representation. This is Texas Association. Yeah, use the mic. Just let me hear it, son. Yeah,
Yeah, so track does not have the buyer's rep
right.
and the IABS that is from the track.
That's Trek, yes.
Okay, so the buyer's rep we use to sign with our client, that is made by the brokerage company where we work actually.
No, it's made by the Texas Association of Realtors.
And this is what we are
That's
seeing
what
right
we're looking
now.
at. Mhm.
All right, thank you.
Yes, sir. Use the mic.
Texas Association of Realtors is the organization you said that offers us protection.
Correct. Correct. They're the ones who have our interest in,
Okay.
yeah, Trek
Does it-
is there for the public.
NAR? Where?
NAR is, it's HAR, TAR, NAR. It's all the same. It all falls under the same.
So what do they do?
What do they do?
I mean, I know that they like set like guidelines and like,
The code of ethics they do, they're the ones who were defending us on this lawsuit. Well, we went from 1 billion to 4 million. Yeah, I mean, we really did not expect to lose it. Just based on the everything, but we didn't. So we got that it cannot be mandatory that you be a member of the association. This form, all the commercial contracts, the listing agreement, all those other amendments, you wouldn't be able to use them if you're an association. We would have to hire a lawyer to write all these up for us. Or exactly, that's not profitable.
All the listing agreements and all the commercial, we make, that comes from. the
That all comes from association. So yeah, listing agreement, buyer's representation agreement, certain amendments, all the commercial contracts and all the lease contracts are done by the association. So you have to be a realtor to use those.
I saw where you can get the sample of it. Where could
Mm.
we get a clean one to have, just in case we were to?
You can get it on Dotloop. You can get it on Texas Association of Realtors. Yeah, and on our agents only, this form that you're looking at that has the red lines in it and it's on there. Oh, you got it. Yeah. Right. If you go to Texas Realtors, they have all the forms on there also. Right, we kind of good on compensation at the moment? Yeah, we'll see how it changes.
changes. Do you think that in a couple of months, we might be having to learn a new buyer agreement and stuff?
Yes, sir. You want me to throw another cog into that? In a couple of months, you're gonna have to learn all new contracts. There's not huge changes to them, but there are several changes that the broker lawyer committee have agreed on that are going to the Trek Commission to be approved. Yeah. I know, it's gonna be awesome. Yeah, now I know what the changes are for the contracts. We just don't know for these yet. They're supposed to be a little bit easier. I'm sorry?
Have you ever been appointed?
I have not. I've applied for it, but I wasn't chosen. No, but you can watch all of those. They stream them live. You can watch them as they're having the meetings. The Trek commissioners, you can watch those live. I was in Austin when they were meeting, so I went and sat and watched it. Yeah. Okay, additional compensation. This is going to, I'm sure, be removed. Yeah, because this says if anyone's offering additional compensation, it's ours. Well, the settlement says it's not. We can only collect what is written. So we always have an amendment, though. It's gonna be kind of hard, though. That's gonna be a challenge. Because you have builders that offer BTSAs. Still offer it. We're just gonna have to negotiate with our client for us to be able to accept it. And they may be asking for half of it or something. They were saying it wasn't equitable for us to be getting more. They think realtors make too much money. Yeah, 25%. Yeah, it's gonna, and they've also said that home prices will come down because of this.
What it is that they're inflating the price so they can pay out. That's the argument.
That's what they were saying, but okay. Do any of y'all own a home? Yeah, okay. So if you go to sell that home and I give you a CMA for that home, are you gonna subtract, let's say 6% off of what I say it should sell for? Because yeah, so it doesn't make sense that they would come down because sellers are not gonna be willing to drop their prices by 6% because of compensation.
They should lower interest rates
Oh,
hand in hand. There should
Well,
be a correlation.
we'll talk a little bit about interest rates. Okay. Acquisition of brokers listings. This would be an intermediary. And what they're saying that if you're buying an intermediary, your agents can be paid whatever's additional. This would be construction, and this only comes into, let's say you represent them and you purchase a lot. And then they say, hey, Mitch, can you help me negotiate with this builder to build a house on that property? On here, I may put X% of the total sales price of that new build. Talks about service providers. Certain service providers like movers, cable companies, carpeting will pay us a referral or give us a referral. Usually like it's a $50 gift card. You always want to disclose. Now, protection period. This is, let's say this runs for 6 months. 6 months and 1 day it expires and they haven't purchased a property. Now, I can put a protection period. Normally I see 60 to 90 days. I've seen it as high as 120. Within 10 days of this expiring, I have to give that buyer the properties that I brought to their attention. If they purchase one of those properties in the next, how many days you have on here, then our compensation is due. It's real hard to enforce this, but you do need to talk about it. With that,
Go, I guess after the.
you go after the buyer. Yep. I've seen it once, twice. In both cases, they used the exact contract that we had written up. No changes. They just waited till the listing agreement expires and the buyer's representation agreement expired, and then they bought the property using the same contract. So we were able to get compensation out of that. Yeah. Well, it was court ordered.
60 days.
They didn't even wait to 60 days. They waited like 6. With this, it's more of a deterrent. You talk about it. If you're going to enforce it, though, you're going to have to watch those properties to see if they go under contract. You're going to have to wait till they close and the title is updated. Then you're going to have to hire someone to go after the buyers for this. What's the number one job of a real estate agent? To get paid? Your number one job as a real estate agent is lead generation. Yeah. Now, all the time you're taking to check on these properties to see if that buyer, you could be lead generating. Now, if it's a $5 million property, it probably behooves you to watch some of them. Yeah. H, this is authorization for the title company to collect our fees and disperse them. So your buyer doesn't have to worry about writing the check. Now, with the changes, they're gonna have to figure out how that's gonna work. They're gonna have to bring more money to the table. All amounts are payable to the broker or paid in cash in Harris County. It's whenever you see that line, it's always going to be Harris County. It's where the brokerage is located, not where the property is located. Paragraph 12 is mediation. So both parties, if we can't come to an agreement, we're agreeing to mediate it. Either party could be held in default for not following this. Whoever loses is going to pay. Now, paragraph 15, I talked about this, and you notice it's bold. Neither broker nor any other broker or their associates is responsible or liable for any person's personal injury or for any loss or damage to any person's property that is not caused by broker. Client will hold broker, any other broker, and their associates harmless from any such injuries or losses. Client will indemnify broker against any claims for injury or damage that client may cause to others or their property. I like that probably just as much as I like our compensation paragraph. With this, if they go new construction, they step on a nail, that's not something we caused. So they're indemnifying. If they're walking through a home and they decide to punch a hole in the sheetrock, it's not something we did. Unless you cause them to do it. Yeah, no.
I was talking about that. Since someone fell,
Mhm.
they broke their ankle.
Mhm.
broke their cut. I think
They can still sue us. Yeah, but we've got this that can help us with that. Doesn't say they won't sue us. They were.
were they?
I don't know about that one. Yeah. Don't let people go up in the attic. Did they? Well,
Liability insurance covers that, right?
Mhm.
The general liability insurance covers that.
General liability for Keller Williams Memorial covers staff, doesn't cover agents. E&O covers agents.
Covers agent on.
On errors, no. Errors and omissions.
Yeah.
Yeah. General liability is something everyone should consider having. Is even if it's covered by E&O, you still may end up paying a lawyer. General liability is pretty inexpensive also. Yeah, look into it. So you have a history, are you saying? Don't let people go in the attic. No. It's a high risk, and that's really what an inspector. Mhm. Yeah. Errors and omissions, closures. They would defend it. Mhm. That's why you need to get it submitted when we have enough time to look for those things. I get that all the time. Right after the option period. Mhm. Yep. No, you're with coaching, you can get your coach to look over them. Yeah. Paragraph 16 is addenda. These, what are ones here are like most commonly used? IABS. Yes. Mhm. Motor remediation and consumer protection. Nice form. We do live in a very humid area. Information concerning property insurance. It's a good form. It talks about property insurance. It also talks about clue reports. Y'all familiar with clue report? Yeah, it's what has been filed on that home. There's also a clue report on you. I didn't know that until I became an agent. And there's an insurance guy talked about it. Yeah, it shows how many times me as an individual have filed insurance claims. It also is a place for sellers to say, you need to disclose. If you even called an insurance company about something, it's going to be on there. They're going to find out. General information and notice to buyers and sellers. The information concerning property insurance, general information, notice to buyer, motor remediation, or a fraud warning are all in that KW form. We put them all together in one. Protect your home from lead. Protect your home from lead. Information about special flood hazards, not a required document, highly recommended. Have y'all seen what's going on up just north of us right now? Yeah. We've had places that have flooded in the last decade, 2 decades, never flooded before. Out in Fort Bend County, they've put in a lot of new subdivisions and new levees. So when there is a flood, it's rerouted. I like that form. And it's just information worth giving. It's not required, but worth giving.
But about seller's disclosure, if a person's home has been flooded, would they list that information? Seller's disclosure?
Yeah, she's asking if a home is flooded, they have to disclose. Yeah, yes. Yep. In the seller's disclosure, it asks any previous flooding. That's one of the changes in the contract. Paragraph 611. It's the new paragraph says seller must provide any mold remediation certificates. That's the gist of it. I don't know the exact wording. That'd be in the change. For your protection, get a home inspection. This is only for use with FHA financing. The KEW memorial form that we have in page 2, second paragraph, it asks, will the buyer hire an inspector? Yes or no? We highly recommend that everybody get their home inspected. Even new construction, get a home inspection.
But don't have a set house. Your set house.
If you know you're doing a FHA, you have to do this form. You're also going to be doing the Keller Williams disclosure. Wire fraud, it's still happening. And it is in 100 different places. I mean, we have it on our disclosure. It's on the buyer's rep. It's on the contract. Title company is going to have it on their information. It's worth talking about. We are never going to send our clients wiring information. Keller Williams, you, me, nobody's going to send them that information. They're going to get it directly from title. This normally has happened like within 7 to 10 days of closing. They'll get an email that looks real formal. Says if you deposit your funds today, we'll discount $500 off of your closing cost. People fall for it. Last one was $35,000.
How does somebody even know that type of personal information that you're about to close?
Good question. That's
Inside.
not necessarily, it's hackers and they may have somebody that's on the MLS that could be feeding the information. We don't know. That's why on the MLS, you cannot put any information about a title company, even on the attachments. You can have on their contact agent for, you can't put the name on it.
Find out what title there's
I know, I don't, it's crazy. It sounds like it, but then, they can hack things and,
somebody locally.
uh-huh. Yeah, I'll pull it up after we're finished with this. If there's any other adding to the buyer's representation agreement, you can add it in the check. Anything that you check in here, it needs to be submitted for review. This is saying that you've gone over it with the client. I know some people just check everything. Don't do that. Special provisions. What can you put in special provisions? Is this a trick question? Yes.
Before you.
Okay. Yes. Yes, by me. Me, the broker, coach, if you have a coach. You understand that on the contract special provisions, the primaries can add things there, correct? Yeah, the buyer or the seller can write things. We can't, but the buyer and seller can because they're primary to the contract. Who are the primaries to this agreement? Exactly. So we have a little bit more leeway when it comes to the special provisions. In special provision, you could put in there, buyer does not want to see any home that is not offering X compensation to the buyer's agent. I like the paragraph that we have in here. When inviting guests to accompany you on showings, you agree to take full liability for their actions. Recording videos or taking pictures of a home must be approved by seller prior to the showing. Neither broker nor any other broker or their associates is responsible nor liable for any person's personal injury. This is when and you will have, Dan was online here. He had a closing last week and the walkthrough showed up with 12 people. Yeah, for a showing. This can be added to here. Just letting them know you can bring people, but you are taking all liability for them.
Something you put in.
That is something I put in. Okay. What else have I seen in special provisions? Yeah.
To have that as standard. Hits or something.
I do need to add in. Oh. Correct. Even with this one, ask one of us, the special provisions on the contract, definitely come and ask someone. The only thing you can, with that, they've redefined that paragraph. If you are going to complete another paragraph, let's say the legal description is real long and it won't fit in paragraph 2, you could put it in special provisions. It's completing another paragraph. We talk about paragraph 5 when it comes to title. You can check both boxes. And then in special provisions, put down that buyer and seller will split title 50-50. Okay. It's completing another paragraph. I don't know. I think in 2 weeks, about 2 weeks. Yeah. Yeah. Most all of my classes are going to be on a Thursday from 1 to 4. Like next week, we're not having one because it's red day. Okay, paragraph 18, additional notices. All commissions are negotiable and not fixed. No one's telling us what we have to list our properties for. We must abide by fair housing and our code of ethics. Understand with fair housing, ethnic or Yeah. Gender. Race.
Tax. So age is not covered.
Profession isn't part of fair housing. Disability, yep. And then for our code of ethics, they've added sexual orientation and gender identification. We don't discriminate for that. Once in a while, you'll get a client that wants to go against fair housing, like a seller. Yeah, had an agent, brand new, first listing. She got a call from the seller. She actually hadn't even met with them yet. She was going to meet with them. And they asked her, "What color are you?" And she asked why. And she was told that these ethnic groups are not allowed in her house. And she very politely said, "I cannot work with you." And that was it. Know what they are and be able to stand up for it. Hey, Carlos. Yes.
It says that the right to speak it.
Fire them. Now, and you may educate them. You know, that is against fair housing and it is against the law. So you may do some education. And we're doing this buyer's representation agreement and the listing agreement, it's in there, so covered at that point. Brokers, property inspector, pest inspector, appraiser, or surveyor, they should get expert opinion. This doesn't mean that you're not going to point things out. If you go into a house like Covington Woods, Old Town Sugarland, went in the living room, you could see the dirt. Was that a foundation issue? I'm not an inspector. I would recommend that you have this inspected by a foundation inspector. Yeah, if you go into a house and you see cracks going from that corner to that corner, could that be a foundation? Yeah, I'm going to point it out and say, hey, if you decide to make an offer on this property, I highly recommend that we get a foundation inspection done. So you're still going to point those things out. You're just don't have the knowledge to say it is definitely this or definitely that. They can have an abstract of the reviewed by an attorney. It's written by an attorney, but it's the title company's attorney. They may want to have their own take a look at it. Y'all are familiar with home warranties? How about residential service contracts? Same thing. That's the official name for them, though. Yeah, they'll screw you up on that one. They cover like the inside of the house. It's very good to have. Yeah, it's very minimal. And it's going to cover your electricity, some of your plumbing, your built-in appliances. You can add to it to cover washer, dryer, refrigerator. We have ours covering our pool. You pay for it, but it can also save you a lot of money. It's a good thing to have that first year you're in a home also. And it protects the seller as much. If I buy a new house, resale house, and the hot water heater blows up next week, seller lied about it and he didn't tell me. Seller really didn't know. So they've provided a home warranty for those cases. I had a seller.
So basically, like, it's a home warranty.
It doesn't relieve them of all. Something like that. Yeah, if they've been honest about it. Yeah. And you can put a home warranty while you have a on the property, which is great because when you get down to inspections, I had one, it was a air conditioning unit. We had put a home warranty on it doing the listing and they paid for all but $90 of the repair. Yeah, it was worth it. And it cost like $75 at the time. You may be monitored when viewing a home. Just take it for granted that you are being monitored while you view homes. People have cameras everywhere. So you don't want to say anything that you don't want the sellers to know about. You also don't do anything that sellers to know about. If you haven't looked on YouTube, there is an agent going to the refrigerator, taking the milk out and drinking right out of the jug and putting it back in the refrigerator. If you go to YouTube, you can see an agent who is having relations with her client on the couch.
Gosh.
Oh yeah, it's crazy. You're going to be monitored. So take that. You cannot photograph or record a home without the seller's permission. Now, if you know you have a buyer that likes to take pictures in the home, or let's say that their spouse or their other is out of town, so they want to do a video, you need to get written permission for that. Just send an email to the listing agent and tell them, I've got a client who likes to do a video of the home. Will the sellers allow that? They're going to tell you yes or no. Mhm. Yeah.
During a showing, are you allowed to carry?
If it's not, we don't have a policy for it here at the brokerage. Doesn't have a policy on it. It's really up to the seller. Oh, yeah, well, yeah, no. Just don't carry unless you know how to use it and been trained. And then again, we talk about wire fraud. The last page, signatures. Brokerage is always Keller Williams, 9000862. Your signature as broker associates authorized signature. Signature. And then your clients. It is not in effect until everyone has signed, including the agent. If you're working with a foreclosure, you're going to recommend that the buyer gets all inspections because it's being sold by a bank. They have no material facts about the property. It may also take a little bit longer for you to get through this because there may be multiple lien holders that I have to approve the contract. 9 out of 10 times, they do not allow an option period, the exclusive right to back out of the contract, but they usually offer an inspection period. So you can get the inspections, you can back out of the contract, you can negotiate. Foreclosures, they will always say as is, no repairs. I can tell you from experience, ask. All they can say is no. And sometimes a bank will tell a listing agent, here's $5,000 if you need to get any repairs done. But if you don't ask, you don't know. So always ask. Short sales. You understand a short sale is an owner who may be behind on their payments and they're selling it for less than what they own the property. If I'm not making my monthly payments on my property, do you think I have the money to do the regular maintenance on the property? Probably not. You've got a seller who's probably going to be very emotional. You're going to have to be ready to deal with that. You're going to recommend that they get all. This says that option fee is never credited. Well, it's not credited anymore with our contracts. Flip property. This is an investor. And you've seen the seller's disclosures where it says unknown on everything. Now, yes, they have to give it, but then again, they don't always give it. Estate properties, no disclosures. Understand that they will have to get all their inspections. You're also dealing with high emotion on the seller side. You have to be really ready to work with that. For all of these, though, if it was built before 1978, they have to do a lead-based disclosure. Whoever owns a property, even a bank, that's a federal requirement. Stucco homes, you're going to want to get an inspection. It's an invasive test, requires the seller's written permission before they can do it, because they're actually going to drill a hole into the stucco so they can get in behind and see what's going on. But we live in a very humid area. You want to get a stuck inspection. Flooded property, extensive. Get the inspections, get the mold inspections. If they say they've had it remediated, then you want to get a copy of the remediation. That's being added to the contract. A property that is leased, that has a tenant in it, the lease stays with the property, not with the landlord. Clients, your buyers need to check with their insurance company to see if they even will cover having a tenant in the property. That's even for short-term rentals. They've got a lease back. The buyer needs to make sure with their homeowner's insurance that it's allowed. Some of them say that no leases. The buyer must be willing to be a landlord. With being a landlord, there are certain things that are required by the state of Texas. The property code, when it comes to landlords and leases, is multiple pages long. There's things that have to be on the property. There's certain ways that they have to account for deposits. Your buyer, who's now a landlord, needs to understand all of that. They need to do their walkthroughs to make sure they meet the property code before you go on the contract. Contract paragraph 4, if there is a residential lease, you're going to check A, and you have to attach the Texas 1953. Even if you're going under contract today and that listing agent has told you that the tenants are moving out at the end of this month, you still need to do that addenda. What if they don't? Yeah. Make sure before your signs that they have good funds in their hands for those deposits. As soon as they take control of that property, they're responsible for the security deposit for their tenant, even if they never got it. So as a buyer's agent, make sure they have it in certified funds. Once they own the property, they need to give the prospective tenant who they are, where they're going to make their payments to. And there's the Form 2210 for that purpose. This is even if it's a temporary lease. Now, for a seller's temporary lease, they don't have to have the property code for locks and everything on the property. That's only if it's a tenant. The 1953 is even if it's a verbal lease. These are just things to know when you're representing a buyer and there's a lease or with the specialties. Check the seller's disclosure to see if there's any fixture leases. That would be like security systems, water softener, solar panels, satellite dishes. Yeah.
Say this was 17 pages.
The lease, yes. The lease is 17 pages. Oh, yeah. 17 pages to lease a property, 9 to sell a property. With the Texas 1953, as far as residential leases, in there it says that the seller will provide a copy of the lease to the buyer.
So if tell you up front that he intends on leasing this property, right? He must tell you that, or what if he doesn't tell you?
That's his problem. This is geared towards there already being a tenant in the property. Okay, so when you go to show a property, it says it's tenant occupied. That's when this comes into play. If they plan on being a landlord, then you're going to put that in the contract under objections. Come to the 1 to 4 class for that. Texas did the disclosure of residential flood for leases. State legislature did that a couple of years ago, but they made no provisions for short-term leases. So even if you have a lease back for one day, that buyer has to tell that seller whether or not the property is in a floodplain and if it's flooded in the last 5 years. Doesn't make a lot of sense, but it is the law. TAR tried to get that repealed this last legislature, which they did. It passed, but then our governor vetoed it. As for deposits, they need to give an accounting of anything that's supposed to come out of the security deposit and that they are current on all their lease, on their rent. Do a walkthrough. Even if it's a lease back, you want to do a walkthrough before closing, and then you recommend that buyer / new owner does a walkthrough again when that owner / tenant moves out. Amendments. Everything must be in writing. Everything must be in writing. Do not cross something out and have them initial it, or cross something out and try to write over it and have them initial it after it's executed. Do an amendment. All forms. There's an amendment for everything. If you're doing something and they say, well, I want it like this, redo the whole form if it's not signed. The buyer's representation agreement, the amendment is the Texas 1503. When requesting repairs, be specific. Seller will repair. Seller will replace. Seller will have property treated for termites, mold, etc. Very specific. If I say seller will have the pool filled prior to closing, what does that mean? What do you think it means? That's what the seller thought. The buyer did the walkthrough and asked, why is the pool still there? He wanted it filled in. No pool. Agent wrote it. Seller will have pool filled. Was not specific. It sucked. It sucked. There was a lot of negotiation. Someone paid some money. They accepted it. No, they wanted it filled in with dirt. They had children. They did not want a pool in their backyard. So they basically wanted it removed. When requesting non-realty items, be specific. Stainless steel double door refrigerator in the kitchen. Last year, buyers went to the home, very upset because the refrigerator was gone. The refrigerator in the garage was there because the agent put refrigerator as non-realty, but did not specify which one. So they left the refrigerator, it just wasn't the one the buyers wanted because agent wasn't specific. Extension of option period. Option must be paid for. There must be consideration for it. You're going to pay for in the contract. If they need to extend that, they have to pay again. So really, it should not be extension of option period. It should be purchasing a second option. Always have to be consideration. We talk about that in the contract. Document, document, document. Broker is required to keep all disclosures, all agreements, all substantial communications, all offers and contracts. So like a couple of years ago, we got 40 offers on a single property. You have to keep all of those. All related addenda and amendments. receipts for disbursement of compensation, property management contracts, which we don't do here, all CMAs. For a listing, it is property code that you have to give them a CMA. Buyers, we require it to be given, and it's just for education. Well, it's important to have a paper trail. If it's not documented, it did not happen. Be careful when you're using abbreviations. I really don't like it when I'm looking at a transaction, especially a contract. And in paragraph 22, it has TXR 2513. Do y'all know what that is? You think a buyer or seller knows what that is? Write it out. Yeah. When you're doing the buyer's representation agreement, you're talking about a CMA. What is that? Comparative market analysis. Always follow up a phone call with an email for documentation. I don't have that form here. Oh, great. Okay, it is going to let me in. Maybe. It's not going to let me in. I wanted to get the KW disclosure and I don't have it. So Brandon and I will be doing a video explaining that. Okay, thank you. I don't think I saved it in here. Yes, everything's in dot loop, DocuSign, KW Memorial Agents only. I wonder if I go here. Someone came in and used this computer and messed up all the settings. We can't get into it. All right. I have some other documents if you're interested. Are y'all familiar with, do you even know that Harris County has multiple fault lines?
No.
That's where you usually get earthquakes. Where two panels of the crust, there's a fault line, so they move.
How did we get to drop? Or is that?
That's something, if you're interested, you can send me an email and I'll share it with you. Yeah. Kind of hard to see, but you can see these fault lines here all over. On the seller's disclosure, it asks, are there any fault lines? There is. We don't have, or knock on wood, we haven't had any earthquakes here. Yeah. I hate it that I don't have that. How do you handle when a buyer says they're waiting for interest rates to go down? Inquiring minds want to know. I just researched this before this class. So right now, interest rates are about 7.33. The last time they were at 7.33 was in 1971. So in 1971, if someone had said that they want to wait for interest rates to go down, the first time it went down was in October of 93. From 7.3 to 1993. It was at 6.87. It did not go below 6.87 until 2002. 2008, it dropped down to 5.97%. So if someone who had decided to wait in 1971, 1979, 1971 would have had to have waited until October of 93. So they would have been paying that interest rate, but they would have been paying it for their landlord for all that time. Now we average, I just looked this up, like $3,000 of equity per decade in Texas. So all that time they would have been losing the equity if they're just wait. What we always say is marry the house, date the rate. Find the house that you love, you go ahead and purchase it. If interest rates go down, which we thought they would go down this year, we're not really sure at this point, they can refinance. But if they wait for it to go down, every other buyer who is waiting for the interest rates to go down are going to be jumping in the market. So supply and demand, what are sellers going to be doing? Raising the prices. There's more demand for their property. There's different ways to handle. When I bought my first house, which was 1993, my interest rate was 8%. This was 14%. In the 80s, it was 20 all the way up to 14 point something. And we still, that's when Gary Keller got in the business, and he's a multi-millionaire now. Well, y'all have any questions about working with buyers? 100 different questions. Do a good buyer's consultation. Have y'all had a class on buyer's consultations? In Bold? Kind of. I always talk about buyer's consultation. You're sitting down with them and getting to know and helping them narrow down what they want. So if I tell you I want to purchase a house and I want it to be around the turn of the century, where are you going to take me in Houston to find a property built around the turn of the century? Okay, let's say my budget's $700,000. Montrose? Well, I want a house that was built around the turn of the century. Yeah,
Like water? Is that-
I don't know. You need to ask. Am I looking for a property that's 124 years old? Or am I looking for a property that's 24 years old? Which turn of the century? No. You need to ask more questions. If I tell you I'm looking for a 4-bedroom home, what's your next question? How are you going to use those bedrooms? So if I tell you I need to have my primary bedroom, and then I have 2 kids, I want each of my kids to have their own room, and then I need a room for an office. So if I found you a 3-bedroom that has an office, would that work for you? Yeah. So then I know I know what I'm looking for. I had a client who wanted a large yard. Our property out in Richmond, which is in a subdivision, is just shy of a 1/4 acre. That's a large yard in my mind. Now, for these clients, I would have probably been looking for things a minimum of a 1/4 acre. How are you going to use your yard? What do you usually do in your yard? So we like to have friends over. Okay, what do you do? Well, we have a barbecue, and that's about it. Well, how many friends do you normally have? 5 to 10. In their mind, they were moving from downtown. They lived in a townhouse. So their yard was, 3 or 4 of these. A large yard was a regular subdivision lot. But if I hadn't asked the next question, you will also find that one person will say one thing and the other person buying the property will say something totally different. Cliff, send me an email and I'll share them with you. Yeah, I had clients. She said she would not live north of Highway 59. He was looking for a nice home with good price. Oh, he sent me a listing, just came on the market. I want to see this property. And I was like, well, Ruben, this is in, I don't remember the subdivision. It's north of Highway 59. Has Anna changed her mind about living north of 59? He's like, no. Do we really need to see the property? But narrowing it down and getting that in your mind. I had clients who they wanted a large master bedroom. And that's kind of hard to qualify. What's large? I asked them, well, what type of furniture do you have first off? So you can kind of figure out. You'll have clients that'll tell you they want a large house. Well, what do you mean by large? A lot of times, can you qualify what a large house is for you? Asking them, what do you mean by a large house? Well, I like it to be larger because I like it to be really open. Perry homes are very open. They have large entries, large windows, so they look very big. If they have a higher ceiling, it looks a lot higher. If they tell you, like, ask them where they live now. They're living in a 900 square foot townhome. A larger home may be 1,500 to 2,000. If you can narrow down to their top 5, when you're out showing properties and you've showed 6, 7 homes, they haven't made an offer, that's when you can sit down and say, hey, when we talked, your make or break were these 5 items. These homes have had 4 or 5 of all of these, but we haven't made an offer. What am I not understanding? What do we need to add to this? Letting clients know that on an average, you show X number of houses. When they look at more houses than that, I've had them apologize for looking at more houses. The one couple I'm thinking of, they wanted an older home and had to have 2 sinks in the primary, had to be a large primary. They had to have an extra room for their rabbits. They had to have carpeting because their rabbits would not go onto hardwoods or tile. Yeah, honestly. They had rabbit money. After we'd seen so many houses and they weren't making an offer, I asked, well, have you considered going to a new construction? And their comment was, we didn't think you would get paid. So I made a mistake when I was doing the buyer's representation. I'm not explaining that. Go look at new construction. A lot of times the builders will pay the compensation to the buyer's agent. The more information I can narrow down with them. Oh, I remember one couple, they had to be in a certain school division, school area with a certain high school. My next question, what would be your next question?
Well, why is it that?
They knew that that high school was the only one with 4 stars in Fort Bend County at the time. My next question was, how old, what grade is your child in? She's 18 months. I was like, 18 months? And they're like, yes. And I said, well, I can find you a home that is zoned to Clements High School. But I can't guarantee that in, 15, 14 years, it's going to be a 4-star. I can't guarantee, even if you're right across the street, that it's still going to be zoned to that high school when she's that age. When they built Aliana, there was a elementary school that if you bought the house across the street, your kids were not going to go there because it was full. They would have to be bused someplace else. Narrowing down what they're looking for, asking those extra questions. Turn of the century, what do you mean by that? Older house. Make it a lot easier. Oh, what other things? When you talk about their pre-approval, is this something that, especially with first-time home buyers, If one of y'all were to get sick or lose your job, could you afford this house on one income? Something to consider. Just when you're doing your buyer's consultation, really getting into as much detail as you can.
We have a question.
Okay,
Buyers.
okay. Okay,
I have a listing.
okay,
He has a listing in Pearland.
I was reached out by an
Ireland.
agent, a buyer's agent, that
Mhm.
says, "Hey, Antonio, I'm an agent. You're listing on 1811 Emerald." Hi, Antonio, I'm an agent. You're listing on 1811 Emerald Pearland. No buyer's commission, question mark. And I said, not on the listing documents, but it could be negotiated with the right offer. Agent response, okay, thanks. I was going to show it.
ooh,
Then I asked, are you still showing it? Agent response, probably not, since I might not get paid. Thank you. That is against the fiduciary of
it
the buyer's
is.
agent, and I could report it. I'm not going
You
to, but-
should do a code of ethics violation.
Okay, that was a question.
Code of ethics, that is a code of ethics violation. You need to report them. Either if you don't report them,
If they really liked it, that they're bad.
mhm,
Yeah. Now, if they told their client, hey, I might not get paid, I won't get paid on this one.
If they told their client, I'm not gonna get paid on this, but you agreed to, that I would get 3% of it, how are we going to figure that out? If the client chose not to see it, that's on the client.
that's
at
on the
that point.
client.
But the agent is doing their job.
The
Right
agent
there,
is,
they're not.
they're not doing their fiduciary. They are in violation of the settlement, which isn't in place yet, but they're mainly in violation of our code of ethics, and they need to be reported.
All right. This has been fun. Thank you
Yep.
guys for spending a moment with Mitch and Brandon. If you don't know about this podcast, it's gonna be live in the next day or two.
Yeah. If you don't report them, then accept the behavior and keep your mouth shut. That's my response on it. Too many agents do that. They say, oh, this agent did this and that. Report them. We've got to police ourselves. If we don't, we're accepting the behavior. And you've got it in writing, so it's pretty easy.
You
Eh.
get the behavior you reward.
Yeah. And since I sit on the professional standards board, I know that would be a violation.
I saw violation on Mitch's face before you finished the text message.
Yeah. No, HAR for an ethics violation. Ethics are separate than TREC.
Thanks, Mitch.
Thank you. Good question. Thank you.
More of a conversation we had about that.
Okay. All right. Because I may not get paid. Nothing like putting in writing. Yeah. Again, and like Brandon said, if he had gone back to his buyers and said that this property is not offering a buyer's compensation, do you want to see the property? Do you want to move forward? It's up to them.
Please don't show me in homes that
Right.
don't
Mhm.
offer this.
I would, since with this going forward, I would point out to anybody now that, hey, this is offering X%, we agreed to this percent. Right up front.
Negotiate, seller says there's no negotiation, but then they change their mind, verbally said maybe we couldn't negotiate. Would you have to put that down in writing or?
Yes. Anything would have to be in writing, but you can negotiate. And as buyer's agent, a buyer came to us, buyer agent came to me this week and said that the listing agent said there would be no negotiations after the inspection. It's like, well, you're going to negotiate right up to closing date. You can negotiate at any time. You could, anything. Well, no, your compensation you're gonna do before going under contract, yeah.
They offer negotiation classes.
Mike McSorley, one of our agents here, he's a certified teacher for the Certified Negotiation Expert designation. That's probably one of the two best classes I've taken. Practice negotiating. The SRES, Senior Real Estate Specialist, dealing with people that are at that age, my age now.
His name is
Mick Sorley, McSorley, I think, or it may just be Y. His office is on this side. Okay, that is all I have. If you have any other questions,
Thank you so much.
you good?
Makes it less scary.
Good, I hope so. And when it changes, we'll do it again. Ha. Cliff, I think you're the only one that's still on. Nope, Gladys is there. So thanks for being on and talk to you soon.